Good morning, West Coasters, and good afternoon to the rest of the country. Welcome to Speech Matters, the UC National Center for Free Speech and Civic Engagement's annual conference. I'm really hopeful that next year we'll be back in person. I'm Michelle Deutschman, the center's executive director, and I'm very excited about the conversations we'll be having over the next 2 days. Especially since the 2020 election, there has been grave concern about the health of our democracy. Our panelists today and tomorrow will help elucidate the challenges facing our republic, underscore remedies, and highlight the role that higher education and all of us play in safeguarding democracy. We want to know what is on your mind, so please share your questions with our experts by using the Q&A feature. We will do our best to address as many of them as we can. Additionally, real-time captions are available here in the Zoom session. Click on the closed caption button and select Show Subtitles to view the captions. Before we kick off our first panel, I have an exciting announcement. The center is launching a podcast, also called Speech Matters. Each episode will feature thought leaders tackling the most pressing issues impacting free expression and democracy on campus and society at large. Our inaugural episode, Cheap Speech and Its Toll on Our Democracy, features election guru Rick Hasson and is available now on our website, Spotify, TuneIn, and Stitcher. It will be on Apple and Google very soon. I also want to extend some gratitude, first and foremost, to Brenda Pitcher, the center's executive assistant, who is integral to today's success as she is to everything that the center achieves. I want to extend heartfelt thanks to the Glen Echo Group for all they do to make the center look and sound and be our best. I want to recognize my colleagues in the Chancellor's Suite at University of California at Irvine and at the Office of the President. And finally, I'd like to thank the members of our academic and national advisory boards for their ongoing support. The center is indeed very lucky to have two terrific co-board chairs, both of whom you'll have a chance to hear from. Berkeley Dean Erwin Chemerinsky is going to join us now to tee up our first panel, which focuses on a technological advance which both benefits and threatens our democratic way of life, social media. Dean Chemerinsky became the 13th Dean of Berkeley Law in July 2017 when he joined the faculty as the Jesse H. Chopper Distinguished Professor of Law. Before assuming that role, he was the founding Dean and Distinguished Professor of Law at University of California, Irvine. Before that, he taught at Duke University, and before that, at University of Southern California Law School, during which time he taught me Con Law 1 and Con Law 2, which, given my day job, clearly had an impact. Thanks for being here, Erwin. I'll let you start things off.
It's really my great pleasure to welcome you to the 2022 Speech Matters Conference. I must begin by thanking Michelle Deutschman, our terrific executive director, for her tireless efforts in putting this conference together. The first of the panels is focusing on the enormously important topic of social media, free speech, and the future of democracy. The social media platforms that exist, the internet, are the most important developments with regard to free speech since the printing press. In many ways, they brought about a golden age for free speech. They've democratized the ability to reach a mass audience. It used to be that somebody would be rich enough to own a newspaper or get a broadcast license to reach a mass audience. Now anyone with a modem or a smartphone can. Now anyone has access to unlimited information. But there's also a huge downside. There's also the reality that lies, false information can spread. Foreign countries can do that in our elections. How do we mediate the benefits, the tremendous gains with regard to speech over social media and the internet versus all of these problems? There couldn't be a better panel to discuss this. To chair this panel is Jeffrey Stone. He's the Edward Levy Distinguished Service Professor at the University of Chicago Law School. Jeff has been my hero, my role model, and my mentor for over 4 decades. After clerking for Justice William Brennan, being a professor at the University of Chicago Law School, he served as dean, he served as provost. He's the author of leading case books and many books about free speech. And so with that, I'll turn it over to Jeff and wish everyone a wonderful conference.
Thank you, Erwin. One of the most fiercely debated issues of the current era is what to do about bad speech on the internet, primarily speech on social media platforms such as Facebook and Twitter. Bad speech encompasses a range of problematic communications: hate speech, disinformation and propaganda campaigns, incitement to violence, limited exposure to ideas that one disagrees with, and so on. Moreover, because the internet is a global communication system, bad speech can arise from foreign as well as domestic sources. These kinds of harmful expression have, of course, existed forever. But the premise of the current debate is that the ubiquity and structure of this newest and most powerful communications technology magnifies these harms beyond anything we have encountered before. Some argue that, left unchecked, at risk. The appropriate remedies for this state of affairs are highly uncertain. And this uncertainty is complicated by the fact that some of these forms of bad speech are ordinarily protected by the First Amendment. Current First Amendment jurisprudence has evolved on the premise that, apart from certain minimal areas of well-established social regulation, such as fighting words, libel, and threats, we should place our trust in the antidote of counterspeech to deal with the risks and harms of bad speech. Of course, it may turn out to be the answer to our contemporary dilemma. Indeed, it may be that the long-standing reliance on the self-correcting mechanisms of the marketplace of ideas will work again, but perhaps not. Moreover, there is already a counter risk that an increase in editorial control by internet companies will be biased against certain ideas and speakers and will effectively censor speech that should be free. Another concern is that internet company owners will never do enough on their own to put in place the needed controls because their for-profit motivations are in direct conflict with the public good and the management of civic discourse. In light of all this, there is understandable concern that those who control the major internet companies will have an undue and potentially dangerous effect on American democracy through their power to shape the content of public discourse. In this view, public intervention is necessary. Now, it's important to remember that the last time we encountered a major new communications technology, we established a federal agency to provide oversight and to issue regulations to protect and promote the public interest, convenience, and necessity. That, of course, was the new technology of broadcasting and the Federal Communications Commission. The decision to subject private broadcasters to some degree of public control was motivated by some of the very same fears about bad speech that we now hear about the internet. People thought the risk of the unregulated private ownership model in the new medium of radio and television were greater than those inherent in a system of government regulation. And like today, those who established this system felt unsure about what regulations would be needed over time. And they therefore set up an administrative agency to review the situation and to impose regulations as circumstances required. But of course, it may be that government intervention in the realm of social media is so dangerous that those platforms should be left to set their own policies, just as the New York Times and the Wall Street Journal are free to do. Section 230 of the Communications Decency Act of 1996 generally shields internet companies from liability, both for speech that they allow on their platforms and for speech that they choose to remove from their platforms. Many critics of internet companies have advocated the repeal of this law and have used the idea of its repeal as a way to get these companies to change their editorial policies, either to stop censoring or to censor more. Overall, we need to imagine as best we can what a new equilibrium should look like as we experience the impacts on our democracy of this new technology of communication. With this background in mind, let me introduce the two experts who will enlighten us today. Chris Lewis is the president and CEO of Public Knowledge, an organization dedicated to promoting freedom of expression, an open internet, and access to affordable communication tools. Prior to being elevated to president and CEO of Public Knowledge, Chris served as the organization's vice president from 2012 to 2019, during which time he led the organization's advocacy and political strategy on Capitol Hill and at government agencies. And before joining Public Knowledge, Chris served as Deputy Director of the Federal Communications Commission's Office of Legislative Affairs and is a former U.S. Senate staffer for the late Senator Edward M. Kennedy. He's a graduate of Harvard University with a degree in government. Our second expert, Mary Ann Franks, is Professor of Law and Michael R. Klein Distinguished Scholar at the University of Miami. She is a nationally and internationally recognized expert on the intersection of civil rights and technology. And she is the author of the award-winning book, The Cult of the Constitution, Our Deadly Devotion to Guns and Free Speech. Mary Ann is president of the Cyber Civil Rights Initiative, an organization dedicated to combating online abuse and discrimination. And she drafted the first model criminal statute on non-consensual pornography, often referred to as revenge porn, which has served as a template for multiple state laws and for pending federal legislation on the issue. Mary Ann earned a JD from Harvard, as well as a doctorate from Oxford University, where she was a Rhodes Scholar. So let me begin by asking both of you, what do you think people get wrong about Section 230, its history, its purpose, or its effects? Mary Ann, you can go first.
Thanks very much, Jeff. And thanks for that question, because I think it's a good way to frame this discussion and illustrate some of the really important values that you have just been discussing. So the question, I think that what does everybody get wrong, or what is so widely misunderstood about Section 230, I think is the kind of standard narrative of Section 230. That is, it's 1996, there's this exciting new form of communication, and Congress makes this very deliberate choice to protect this burgeoning industry and to give it some time to develop on its own so that it doesn't become overly restrictive. And that Congress is very much of the view that this is a medium that has tremendous potential for free speech, and that is why we would give it this kind of special treatment. I think that's an accurate history up to a certain point. And the point that I think, to which I think it's not accurate, is the extent that it was already known in the 1990s that the internet was going to be capable of both connecting people for wonderful, democratic, pro-social reasons, but also for people to connect with each other to humiliate, degrade, harass, and inspire violence. We know that in the 1980s, already white supremacy groups were using the internet in a way to get more people to join with their ideas, to proselytize, to organize attacks, to celebrate the violence that they had committed. And so in the 1990s, when you have this move by Congress to say, this is going to be wonderful, we're going to have all of this wonderful new free speech, and we can just let the industry sort of develop on its own, there was, I think, either a deliberate or maybe just a negligent sort of inattention to the kinds of harms that were already clear at that time. And then I think what we've seen as that has evolved is there are people who would say Section 230 is perfect, nothing about it should change. If we change anything, we're going to end up censoring speech and we'll end up like totalitarians, the internet will die. And then there's people who are saying that everything's wrong with Section 230, get rid of it, and we need to do something about that extensive immunity that the industry is experiencing. And I think that what's really important in that discussion, and we can get into more of the details in our discussion, is that Section 230 does two very different things. And when people talk about changing it or what's good about it, they're often talking about very different aspects. And clearly, to make that clear, there's one section of Section 230 that says you get this really extraordinary civil immunity for content that you leave up, content that you decide to exist on your platforms. That's one part of it. This is C1 saying that's what you get immunity for. And then you have the section of Section 230, which is the takedown provision, which says when these companies and platforms decide to remove information or to not post information or to edit information, that they're also going to get civil immunity for that. And so I think it's really important to understand when people say it's great, it's bad, it needs to change, to be very specific about which part of Section 230 they're referring to. I think that it's really telling, especially in the given the political machinations over this whole debate, that very broadly speaking, Democrats, progressives, et cetera, are mostly worried about C1, that provision that says there's really very little chance that you're going to get sued over content on your platforms, even if you monetize it, even if you promote it. I think there are many people who are saying that's a problem because it is really giving a kind of immunity to that industry that no one else has and really misaligns incentives. Whereas broadly speaking, Republicans and conservatives are really focused on that second part, saying, we don't like it when you take things down. We don't like it when you ban Trump from Twitter. We don't like it when we think that there is some sense of bias going on against conservatives, even though empirically that has been shown to be to have no support. So I think that it's really important that we understand that there's a more complicated history of Section 230 than maybe we think. That is, it's not all about, oh, what did we know in the naive 90s? We're only now catching up to what could happen. Maybe not really quite true. And secondly, to be really aware of what different types of roles or what different types of protection Section 230 provides, who's uncomfortable with it now, what they want to do about it, and what the relative strengths of their arguments are.
Thank you, Mary. Chris, what do you think about this? And also, what do you think about the power imbalances that we currently have in our digital platform marketplace?
Well, first of all, thanks, Jeff and Michelle and the UC Center. I appreciate being invited back. And I love a lot of what Mary Ann had to say, especially the point about how we can't be have a utopian attitude about what we're facing online, that there are real harms. And I think that's true. But as someone who has defended 230 for a long time, I think it's fair to say that there's good and bad that comes with the communications that we see on the internet. It doesn't necessarily mean we need to just strike the law away. I think some of the your first question about misunderstandings about the law, some that I hear in the debate are that folks think that just eliminating Section 230, for example, will solve the problem. That if you eliminate that immunity protection, that you can then somehow go after, let's say, a social media platform or a website for certain speech. I often then say, go after them for what? Because as you noted, you take away a liability and still much of the speech that we find that is bad, that is harmful, hate speech, disinformation, is not illegal speech. And so, we still have to answer that question of what do we want the law to say about what is legal, what is not legal, what is allowed online, what is not allowed online, whether you have Section 230 or not. But what we do concern ourselves with Section 230 is that if you eliminate that liability immunity that that Mary Ann described so well, that you will have a disincentive for platforms to create spaces for community and speech. And so there's a balance to be struck there. How do you, as we like to talk about at Public Knowledge, how do you target the real harms that are happening online without losing the benefit that Section 230 provides that we never had before in older communications tools? I'll remind folks that people often think that it is a blanket immunity. You hear that a lot from legislators, that it's a blanket immunity. It is not a blanket immunity. There was a court case called roommates.com dealing with, platforms that deal with rentals and housing on the local market. Think of like an Airbnb, where I think the court rightly determined that Section 230 did not protect them when it came to local laws around housing discrimination. That's important, that we don't extend the immunity of Section 230 broader than it was intended to be. And I think it's also important to remember who it covers. We often think about Facebooks and Twitters because they're so ubiquitous in our culture, but it also covers internet service providers. It covers platforms that you wouldn't think of what they do as speech, but how they structure their platform is often viewed as speech. And so there's many nuances to it, and this is why as I said before, I don't think we need to eliminate Section 230. We need to be very smart and specific about how we deal with the harms that we're seeing online, if there are tweaks to it, or if there are other ways, and I think there are, other ways to get at some of these harms, or at least other ways that we should try before we look at eliminating Section 230. And it's because of the power dynamics that you asked about online. The internet is special because it is many-to-many communications, interactive in real time, something we had never seen before it was created. And so the early examples of communications technology that you cited, Jeff, when it came to the Federal Communications Commission, they were one-to-many in broadcast, they were one-to-one in telephone. And while, yes, the same values and concerns were brought up then as they're being brought up now, the technology now is so different because of how powerful it is, the scope of the technology, the speed at which it can move. And also the way that has, we hope, empowered the public for low cost, for low barriers, create speech and create community. That power has shifted as the internet has matured. And I think that's where there's room to look at reform and to look at policymaking, because that power has shifted where we now see platforms, especially ones that monopolize or dominate certain sectors, as gatekeepers. And with that gatekeeper power, because of the data that they collect and because of the network effects that they have, more powerful network effects than we've seen before in any other communications tool that we've seen. If it isn't exact math, but if cable, if every time someone joined a cable subscription, the network effects grew by 1 or +1, the networking effects of the internet and of social media platforms is exponential. It's 1x instead of +1, because once your friends and your family, everyone knows this feeling. If they're on the same platform as you, you don't want to leave, and you feel like you're missing out. From an entrepreneurial perspective, on the flip side, when I talk to tech startup entrepreneurs and VCs, they talk about it as a cold start problem, that they simply don't invest in areas where they think they can compete because of how hard it is to win users away. So if we can work on promoting competition and choices, I think there's room to work there before we turn to things like reevaluating the First Amendment or totally eliminating Section 230. And that's where we're focusing a lot of our work and solutions.
So, Marianne, what do you think is at stake in the current debate over Section 230 reform, and should it be reformed? What's your view on that?
I think it should. And I think that a lot of what Chris is talking about that I agree with, in terms of we need to worry about that kind of dominance that we're seeing from a handful of companies that have really taken over the internet. This is a problem that needs to be addressed. Where I think we differ is that problem comes directly out of Section 230. That is, when we say, oh, it's not a great situation where we've got effective monopolies here, we've got this kind of control over our public discourse, my view is that part of the reason why we get here is because you have that part of Section 230 that says you're basically not responsible for harmful actions on your platform. Now, of course, as Chris says, there's limitations, but there's not that many from the perspective of a company that's looking at, can I cash in from people's content, knowing that the kind of content that's really profitable is the kind of content that upsets people, the kind that really makes people angry, the kind that gets people worked up. I can use that. If I'm a platform, I can use that. They can do all kinds of dangerous things. It can cause all kinds of harm. I put the money in my pocket and I don't have to worry about getting sued. The natural consequences of that system are going to be exactly what we've seen, which is major billion-dollar corporations swooping into that space and making it extremely profitable for them to engage in really reckless and negligent practices. So I think when we say, does Section 230 need to be reformed, it's precisely because most of us care about that asymmetry and that kind of dominance and these kinds of commodifications of what we think of as free speech. We have to rein that in by changing companies' incentives. It's not just a Facebook, former slogan, move fast and break things. That's the tech industry's whole MO. You break things, you make the profit from it, you get called before Congress, you have to answer some uncomfortable question, nothing changes, and you keep making money, and you say, look at this new shiny object we've developed, the metaverse or whatever it is. So without changing Section 230 C1, again, want to make it really specific that that's what we're looking at, we're not going to get the kind of incentive change on the part of companies to think about how much they should put resources into making their programs, platforms, services actually good places. And when I say good, I don't mean substantively that people need to agree on things or they need to be nice to each other. Doesn't matter. What we're talking about is the same thing we would ask for in any offline space, which is, are there spills on aisle 7 that you have been ignoring? Are there no lights in the parking lot so that people are getting assaulted? Are you selling guns to people who are telling you, hey, I'm about to commit a crime, right? So are you actually creating spaces where people are discouraged from foreseeable harmful activity? And right now, Section 230C1 says you don't have to put any thought into that. So I want to be clear that that's the Section 230 reform that I think is necessary. I want to really make clear that the Section C2 reform that Republicans, especially, and conservatives are trying to argue in places like Florida and Texas that have passed these absolutely unconstitutional and crazy laws where they're attempting to force social media platforms to keep things up or to keep their access open to all comers. Those things, I think, quite clearly do violate the First Amendment, those types of attempts. Attacks on C2 are really attacks on the First Amendment. They're attacks on private companies' rights as private actors to make their own decisions about whether or not they want to associate themselves with certain speech. That's an important protected constitutional right, and the rights of association as well. So I really want, that's an easy doctrinal point, but a really difficult one politically, that any attempt to reform Section 230 that's targeted at private companies' choices about what to eliminate, about who they don't want on their platforms, I think are non-starters and really harmful. Where we really do need the action is on that first part, which is, and I'm glad that Chris has reminded us of this. If you take away Section 230C1, what really changes? Nothing by itself. That is, it doesn't suddenly make things illegal. It doesn't suddenly make protected First Amendment speech unprotected. It doesn't give you a natural right of action. It doesn't mean the platforms are immediately responsible for anything. It's taking away one particular kind of defense and a procedural kind of benefit that these companies have had. And my answer to that is that that's a good thing. We don't need to know what the outcome is going to be in any particular case about particular speech or conduct. What we need is to make companies actually have to think before the fact. If I promote this particular product or service, let's say it's live streaming or whatever it is, do I have to worry that if someone gets killed or someone is live streaming a suicide or a mass shooting, may I ever get sued? The answer may be you might never, even if it gets all the way through the merits, because it's really hard to prove causation and it's really hard to prove a theory of action. There are all these hurdles to anyone who's ever going to want to hold a platform accountable for harm that results. But what would be good for the industry, because it's what virtually every other industry has to think about is it possible that under some circumstances, our company could get sued? We want them to think about that. We want them to be a little more circumspect about the choices that they make. We want them to consider the negative externalities of their products because we want them to have safer products. So I think that's absolutely essential. And the contrary view of this, the Section 230 that has been widely interpreted by the courts way past whatever roommates.com might have suggested, has essentially given a kind of a blank check to the industry to say, do whatever you want and don't worry about it. And that definitely has to change.
So the question there is, given the fact that there are, I assume, billions of posts on Facebook every day, how is Facebook supposed to do this?
Well, a lot turns on what it is we were asking Facebook to do. So what we're asking is for Facebook to absorb the costs of its risk. That is to say, when you have billions of pieces of content, first of all, Facebook doesn't have to have billions of pieces of content. They can choose to be smaller. So I worry that some of the criticisms are, we're too big to fail, we're too big to be regulated. Part of the answer to that, I think, if we were to turn to some other industries, is to say, why would that work in another context? If a car company says, well, we make so many cars, we really can't be expected to make sure that they're all safe and have airbags before they come off the line, I think we'd all say, well, then make fewer cars and make sure that they're all safe when they come off the line. So I think we want to make sure that we don't assume that we have to have a social media company that has billions of pieces of content flowing through it. And if the company is saying, well, we can't be sure that's not going to get someone killed, well, then the answer should be, you need to be sure, or at least you need to take reasonable steps to deter foreseeable harm. So one of the ways that Facebook could do it in practice, if they don't want to reduce the amount of content that they're dealing with, is to think of something more like a distributor model, which is they only become responsible remotely, even possibly responsible, if they've been on notice. They're given notice that there is a plausible threat or actual unlawful content, and they have to respond in some way that seems reasonable, that they just can't ignore it and pretend like it doesn't exist. So it wouldn't be that the only way to deal with Section 230, if we were to roll back Section 230C1, the answer would not then be screen every single post. It would mean respond within a reasonable amount of time in a reasonable fashion to complaints that seem credible about content that might be on the platform.
So Chris, what do you think about that? Is that in your view a viable approach?
You know, I think there are, again, as I was saying, I think there are steps along the way that we should be trying. And I don't know that what Marianne is describing, and some of what she's describing, I think are good ideas. I don't think they require repealing Section 230C1. Putting obligations on communication services of various types has a long history in this country. We did this with broadcast because they were using the public airwaves, and we said they had a public interest obligation to do certain things. I would love to have a conversation before we talk about eliminating Section 230 about the obligations and the oversight that we need to put on top of these platforms. Public Knowledge, we were one of the first organizations, I think we were the first back in 2018-19, to call for a digital regulator over digital platforms. What would that regulator do? They can do a number of things. First of all, they can participate in the conversation about competition, but competition alone isn't enough, but we think it's important. But also to have an expert cop on the field that understands, has the expertise and the authority to look at the different business practices of digital platforms. Every digital platform works differently. So if we're only looking at social media, then we're going to miss what's happening in search. If we're only looking at search and social media, we're going to miss what's happening in marketplaces. And all of those platforms function differently. We see them have anti-competitive harms that are different based on how they use data. And we see content harms differently based on how they're set up. So we really need an agency with the expertise to look at the business models that they're practicing and have some oversight. I think algorithmic oversight is incredibly needed. And right now it's only being done in civil society and academia. Nowhere is the government. The power of the people, we talk about power dynamics, where their government says, no, you will be audited, have your algorithms audited to make sure that they aren't naturally discriminating or naturally driving hate speech. These sorts of audits that are done in civil society and academia, why can't they be done by the government and expectations set based on them? So then you're starting to put some of the obligations that are closer to what Marianne was saying onto these companies. And there's probably more, we don't have an answer, but to entertain the idea that we are not powerless to govern these companies, that they are just businesses with business models where they can make different choices with their business models. I mean, just the problem alone that Marianne highlighted about how social media is set up for you, they try to keep you on the platform. It's very true. That's based on the fact that they follow an advertising model where they want to collect your data and give specific ads to you. But not every platform, not every social media platform follows that business model. There's an interesting story about Reddit that I think we need to investigate, where they used to be a cesspool, and they probably have corners that still are cesspools, but they have gotten credit for how they've changed some of their moderation with community moderation. And they also don't do the same sort of targeted advertising that Facebook does. We need to study these different models and see if they give us different outcomes. We need to study algorithms and set expectations for how they're used. And I promise you, no matter how well interested our policymakers are, no matter how much they want to yell at a CEO, they can't keep up in Congress with the pace of technological change. And so having a digital regulator also puts the experts in a position where they can adjust and move as the technology changes. So I think that's a stronger way to go. It gets at both competition and public interest standards. And it's a step before you think about eliminating Section 230. Not that there shouldn't be reforms to 230. We've already said we don't think that advertising should be subject to 230 protections. Other pay-to-play opportunities where there's already significant looks by the company, they're already screening ads, so why not screen them for real harms? Those are sorts of things where we think you can have some rollback, but I want to be cautious about broad rollbacks of whole sections of the law.
Thank you, Chris. We're going to start taking questions in a couple of minutes, so anyone in the audience who has them, please use the chat function. I want to make one other comment myself about this, which is the extent to which social media endangers democracy itself. And one of the ways that they operate that I find most troubling is the use of algorithms in deciding what gets sent to all of us. And the reality is they want us to keep going back to Facebook or Twitter or whatever. And so they have algorithms that send us things that reinforce what we've already liked. And the effect of that is they are not interested in sending us things on the other side, ideologically or politically. And I think that's part of the cause of the current polarization in our society. So many people now use these means of communication and means of getting information, and they're not even aware of how much the information they're getting is distorted by the algorithms that they're using that send you the things that reinforce what you've already liked, what you already believe in, and that moves people further and further away from one another. So let me turn to the Q&A part of this. So one question is, what do you think about the war between Russia and Ukraine? How do you respond to misinformation in a respectable civil way? And what do you think about Donald Trump's endorsement of the war, as well as using it to find dirt on the Democratic Party? I'm not sure that's relevant to our discussion, but if either of you wants to take it on, go for it.
Well, Rand, do you want to go?
Well, not so much on Ukraine, I would say, although maybe before we talk about specific, I take the question as a very specific question about here's a problem. What is social media doing to either fan the flames of it or to actually provide some much needed democratic intervention and oversight? But I because a lot has been said in the last few minutes, I just want to make clear that my own view is that it's not an either or. So Chris, when you talk about the regulation, the regulatory agency, I think all of that sounds good. The reason why I think it's incomplete is because one way of looking at what Section 230C1 is doing currently, as it's interpreted by the courts, and I think maybe you and I agree that it doesn't have to be this way, but I think after Zarin versus AOL, we're kind of stuck with a very overly sweeping textual interpretation of Section 230 that is going to be impossible to reverse without reform. The problem is that it's shutting the courtroom door on average individuals, right? I don't want the entire fate of what happens in terms of the tech industry and its impact on all of us to be left up to simply people who are, sitting in a regulatory agency, right? What we want to be an important piece of this is for individuals who are harmed to be able to go to that industry and say, you harmed me, you're responsible, you need to submit to discovery, we need to know more about what happens under the hood, and we need to get some case law about what the connections are between what a platform does and a harm that a person experiences. And for 20 years, we basically had none of that. When Frances Haugen says no one knows what happens at Facebook except Facebook, right? We don't know how much they are actually manipulating deliberately certain types of processes or procedures, what they actually know and what they don't, whether they're being negligent or reckless or intentional, because they don't have any incentive to tell us. And so an important part of it, as you say, is regulation, but another part of regulation is regulation by the people. And when C1 essentially says we're going to keep the companies out of the courtrooms, we're going to get all of these cases dismissed at the motion to dismiss phase, so we never get discovery and we never even get to know what the connections could be. Until we do something about that, we're missing a really important part of democratic oversight coming directly from people who may have been harmed. And I think that links directly to Jeff's point, which is larger impacts on democratic expression and about the health of democracy generally. There's the algorithmic problem, but there's also a question of when we prioritize provocative, profitable speech, we're not actually engaging in, I think, the values that the First Amendment is intended to protect. truth, autonomy, democracy, what we're doing is we're privileging certain types of speech over others. And it is entirely observable that certain types of speech left unchecked silences other types of speech. When you allow unchecked harassment, defamation, non-consensual abuse, non-consensual pornographic abuse, when you allow for deep fakes, when you have all of that being unchecked, what you really are doing is you are silencing women, silencing people of color, silencing people without privilege, either politically or otherwise. And so we're always trading off certain people's speech from other people's speech. And that trade-off in the current status quo, I think, is the wrong trade-off. And we really need to understand that we're not, by doing nothing or letting these industries decide what they want to do about this, we're not actually protecting speech for everyone. We're protecting speech that directly serves corporate bottom lines, and that is not a democratic value.
Yeah, let me respond and also bring it back to the question about Ukraine, or I'll try on Ukraine and Russia. It's close, but it's not exactly related to what we're talking about. But no, Marianne, my only argument about a digital regulator is that regulatory bodies charged by our elected officials with authority, with resources, and with a mandate to work in the public interest, whether you're talking about the FCC or a new digital regulator over platforms, that is democratic oversight. Created by our own elected officials. There are rules about engagement. So yes, you can. I'm not saying you can't have private rights of action that lead to discovery in court, but you can also find out what Facebook knows by requiring that they tell a regulator with experts what they know. And those records are public. It's why you have public participation at the FCC and at other regulatory bodies. There are laws about this with the APA that information has to be shared in the record and can be found by attorneys who want to make a private right or not. So I think it can contribute to what you're looking for about discoverability and evidence about what we don't know, because you're right, we don't know Haugen's right, we don't know what's happening with Facebook except when they tell us, and we have to get answers on that. The question about Russia and Ukraine, what I react to in that question is really the concern about misinformation. And while misinformation is not illegal, it can be curbed. And unfortunately, what we've seen from former President Trump and some other elected officials is that they don't want to see it curbed. And they consider that a threat against their right to speak. I think that is ridiculous. And it's a real concern of mine that we're seeing on the right an attempt to redefine what free speech rights are by saying that you don't have the right to be criticized, you don't have the right to have your content commented on or labeled. That is ridiculous. And we want to encourage that type of content moderation on platforms. I think it will help with misinformation. It will not eliminate misinformation by any means. But if you add to that actual competition on platforms, choices on where you can go. If you don't believe that the platform that you're using, let's say you're a Facebook user and you don't think that they label or add alternative factual information to counter misinformation well enough, that if we were able to promote competition so that you go to another platform without losing out on the network effects that are so strong right now with a Facebook and its dominance, then we could have competition and choices for consumers based on how they moderate, how they fight disinformation. I think that would be a positive thing. And there are proposals right now moving through Congress that we think will promote that sort of competition. These are laws around interoperability for social media and other types of platforms, so that if you move, you can still, your social graph still works. You can still talk to your friends and family who are on the other social platform, but maybe you're on a platform that has stricter rules for content. And so you may not see everything on that platform, but you can still communicate. You can still engage in some of the social engagement, social media type communications. It's not clear exactly how they would work, but we believe that there are computer scientists who look at using APIs and other tools to make that possible. I think that would be a really progressive move to promote competition. Also, rules around non-discrimination, laws around non-discrimination are moving through Congress, and other pro-competition protections that are important that could be dealt with at a digital regulator agency, where they could again adjust them and massage them based on the technology as it develops over time. What does interoperability look like on the metaverse? I have no idea. An expert agency could actually look into that as the technology is being developed.
So unfortunately, we have only a couple of minutes left, so we're not going to be able to get to very many of the questions. But one interesting one, which I just lost on my screen. Damn, where was it? It's to Marianne's important point. What can or should we be teaching undergraduates about this set of issues regarding the idea of democratic oversight and not just highly technical legal regulation?
That's a great question. And I'm so glad for the opportunity to link this back to, one of the underlying values of this series, which is asking the question about academic institutions and the role that they play in democracy and in fostering good speech, good free speech norms. And I think a huge part of it is looking to at least the version of the university and the idea of a university as a way to think about so many of these issues. That is, when we think about what a good university provides, it's not that you just have anyone come in at all times to speak about whatever they want. Good university experiences expect that you're going to be an informed person, a relatively civil person with good ideas, and that we don't have to throw open the doors of the university to anyone who just wants to come in to have a conversation or to scream racial slurs, but that there are obligations and there are standards and there are practices. And that academic freedom doesn't mean let's explore every idea, because not every idea is worth exploring, but rather let's explore important ideas and give reflection and support to good arguments and not reduce things to questions of political affiliation or whatever else irrelevant sort of considerations that might come into play. So I think there's a huge opportunity for universities to really affirm the ideas of an institution that are not like social media. Because if you think about it, the way that social media and academic institutions operate are so much at odds with each other. That is, social media rewards immediacy and impulsivity and provocation and all of these things that in a university setting shouldn't be rewarded because they're not good for the project of trying to do collective truth seeking. So the idea that you would slow down, the idea that you wouldn't respond immediately, the idea that you would want to do real research, not just the Google search, all of those things that we can instill in the academic institution, I think, are important, which is all the more reason why this other part of the cross-cutting debate here, which is an attack on universities and their ability to have these kinds of norms, is so dangerous. And it's not a coincidence that they're happening at the same time. That the same political forces that want to force social media companies to take all comers and to never enforce their terms of service are also attacking universities and K through 12 and trying to tell them what they can't say, what they can't teach. And this is really a terrible moment and a precarious moment for our democracy. And those two conversations, what social media should be doing and what universities should look like, they're very much connected and important.
And Chris, I'm sorry, we're out of town.
Okay.
So I'm sorry we didn't get to more of the questions. Thank you both, Marianne and Chris, for a great conversation. It was really terrific. And we'll turn it over now to those who are running the show to get ready for the next panel.
I'm running, but I think I'm running it, but I think we have time for Chris to answer that question, and then we'll officially close if that works. And then I can thank all of you officially.
Oh, well, I'll just say then, thanks, Michelle. What Marianne is saying, I agree with. I think it's important to add to it that so universities, colleges definitely don't need to take all comers. I like that they do allow space when people are civil for debate, and I assume Marianne would agree with that. What to connect it to social media and digital platforms is that the great thing about the internet is that we have, like you said, low barriers of entry, and then we have infinite channels. And so the internet does not have to limit access to just ideas that are worthy of debate. We may not like that. We may not like what ideas people want to put forward, but I think they should have access to the communications tool itself. And so by providing interoperability and competition, just like the printing press, the tool could be used for things that we hate, but still respect people's free speech rights for things that we might find abhorrent. And then by promoting competition, you can also then put social pressure and demands, as we have on movies, television, radio. You can put those demands on the more mainstream channels, on a Facebook, on a Twitter, that they need to moderate in a certain way. And we've seen that start to develop over time. The Stop Hate for Profit campaign a couple years ago, we gave them an award. Great boycott pressure to get Facebook to clean up hate speech on its platform. And yet, Facebook's response was, well, they'll be back. The users who participated in the protest came back because they had no choices. They had no other platforms to go to.
Thank you. I'm back, and I wish we were in person so I could really thank you, but I want to thank all of you so much. I knew when we had our prep call that this was not going to be enough time, and the level of engagement is exceptional with so many questions, which we will save. And I reserve the right to invite each and every one of you back to potentially do a podcast episode. I want to just make sure everyone knows that Jeff is co-editing this forthcoming book, which is how we got the title of this amazing session, which is Social Media, Freedom of Speech, and the Future of Our Democracy. And Marianne is one of the contributors to that. So I'm looking forward to getting signed copies. I also want to note that Jeff is one of the inaugural members of the Center's National Advisory Board, and his mentorship and support is part of what has allowed us to get here. And Chris, you are one of the few two-time Speech Matters guests. So everybody has a special role, and I want to thank all of you. And I realize that I'm going to nerd out a little bit here with my legal eagleness, but we're kind of just moving from one of interesting legal topic to the next. Social media is definitely one of the threats to democracy, but now we're going to focus on another, and that is the January 6th insurrection, which really struck at the heart of our system of government, which is the peaceful transfer of power. And in my opinion, one of the most interesting legal developments since January 2021 was Free Speech for People's decision to bring a novel challenge to the candidacy of North Carolina Representative Madison Cawthorn for his role in the January 6th attack. And to help us learn more about this case, we are privileged to be joined by Ron Fine, who is Free Speech for People's legal director, Leslie Garvin, the executive director of North Carolina Campus Compact, and Lewis Pitts, a retired civil rights attorney from, you guessed it, North Carolina. Leslie, it's a pleasure for me to pass the baton to you to kick off what I know will be an interesting conversation.
Thank you, Michelle, and welcome to all who have joined us for this relevant and very compelling topic. This idea of January 6th and responding to it using the 14th Amendment, specifically Section 3. And I am very excited for this conversation. However, I am going to set a little bit of context because a lot of life has happened since January 6th. And I think that will just set the stage for our conversation. So let's go back to January 6th, 2021. On that day, a joint session of Congress was set to convene in the US Capitol to certify Joe Biden's electoral vote win. At the same time, on the ellipse about a mile away from the Capitol, thousands of Trump supporters were gathered for a Save America rally. One of the speakers at the rally, and you saw a picture a moment ago of that, of his presence there, was Madison Cawthorn, who had just been sworn in 3 days prior for his first term as the US representative for North Carolina's 11th congressional district. He also happens to be the youngest representative in office today at the age of 26. So during his speech, he actually was at the rally, which occurred 3 days later. And during his speech, he continued his belief, which he had shared prior on social media, and promoted the rally. That, in fact, the election, that there had been election fraud, and that that the results were invalid. Around noon, as we all know, Trump spoke towards the end of his speech. Thousands of folks made their way to the Capitol. Eventually, around 2 p.m., the crowd broke through the police barricades, violently stormed the Capitol, and we know what resulted from that. It's important that we now jump ahead to November of last year, when Madison Cawthorn announced that he would run for a second term. In response to that, on January 10th of this year, a group of North Carolina voters filed a legal challenge before the North Carolina State Board of Elections. The challenge alleges that Cawthorn is constitutionally disqualified due to his involvement with January 6th to run again for office. Again, the challenge is based on Section 3 of the 14th Amendment. I will also add that just recently, March 24th of this year, another group of voters from Georgia filed a similar legal challenge to Representative Marjorie Taylor Greene's candidacy for re-election in 2022. So that is just a very brief setting of the context. And now we're going to dive more deeply into this interesting and complex conversation. We are fortunate that we have Ron Fine with us, who again is with Free Speech for People. He's the legal director, and they are the organization that serves as the co-lead counsel in these cases. Ron, please tell us about the mission of Free Speech for People.
Thank you. Free Speech for People is a national, nonpartisan, nonprofit organization. We were founded on the day of the Supreme Court's decision in Citizens United versus FEC, and that was in 2010, and since then have been engaged in cutting-edge work to renew and reclaim our democracy.
Okay, so now tell us about these lawsuits.
Thanks. I'd like to begin with some background on Section 3 of the 14th Amendment itself, because this is a provision of the Constitution that even most lawyers learned about it once in law school and then mostly forgot about it. And Section 3 was actually considered by the framers of the 14th Amendment to be one of the most important provisions. The parts of the 14th Amendment that are most well known at this point involve, for example, equal protection of the laws and granting, extending the Bill of Rights to state governments as well as the federal government. But in 1866, this section is the one that weighed most heavily on the minds of the Reconstruction Congress. Because what had happened was the Civil War was over, and then the ex-Confederate states sent back some of the same people who had led the Confederacy into Congress, ex-Confederate military officers, senior cabinet officials, and Congress said, we can't allow this. And the reason we can't allow it is because it poses a threat to the Republic. If these very insurrectionists and rebels are allowed to just waltz right back into the halls of power. So what Section 3 says is that anyone who took an oath of office to support the Constitution as a member of Congress or in other specified offices, then broke that oath to engage in insurrection or rebellion against the United States, is disqualified from all future federal or state public office. There is a provision that Congress can grant an amnesty by a vote of 2/3 of each house, but unless and until that happens, anyone who took that oath, broke the oath, and engaged in insurrection against the United States is disqualified from any federal or state public office. So this provision was used quite a bit in the years after the Civil War, but then it fell into disuse, and that's for two reasons. One is that Congress did in fact grant amnesty to most of the ex-Confederates after a period of time. And secondly, there haven't really been any other insurrections against the United States, certainly not any in which members of Congress or other officials have engaged. So there hasn't been a lot of opportunity to apply this provision in recent years. That brings us, of course, to January 6th. And after January 6th, a lot of people became aware of Section 3 of the 14th Amendment as something that could apply, whether to Donald Trump or to some of the members of Congress who were involved to one degree or another in the insurrection, as well as many lesser officials who had some role. But a lot of people thought that action on this would have to come from Congress itself, that Congress would need to pass a new statute or have some special vote or inquiry in order for Section 3 to apply. And at Free Speech for People, we realized that there is actually no need for a specific new congressional action because states have control over who appears on the ballots for office for Congress, for president, and for anyone else. And in fact, most, if not all, states have procedures for testing or challenging the qualifications of somebody who is running for office to appear on the ballot. And if they don't meet the qualifications for that office, they can be excluded from the ballot. So we at Free Speech for People have now filed two such challenges, as Leslie mentioned. One against Madison Cawthorn in North Carolina, and the other against Marjorie Taylor Greene in Georgia. And in these challenges, we have three elements to establish. One is that they took the oath of office. This is not really in dispute. Both Cawthorn and Greene, were sworn in as members of Congress on January 3rd. The second is that there was an insurrection against the United States. Now, I'm going to say no serious person disputes this. Marjorie Taylor Greene claims it wasn't an insurrection, but there's not a lot of support for that position. It met any definition of insurrection that you might apply. The word is not without a definition. It had a meaning in the 19th century, and there's a meaning today, both of which would include a violent uprising that not only takes over the very seat of government, not only where there people are roaming through attempting to find and execute the Vice President of the United States and the Speaker of the House of the United States, but also that it effectively stopped the peaceful transfer of power. So that's the second element, an insurrection. And the third part that we need to establish is that they engaged in insurrection. And that term engage is, of course, in the text of the amendment. And the question is, what does it mean to engage in insurrection? Obviously, the people who stormed the building engaged in insurrection. The question is, what about the people who helped facilitate or promote the insurrection, but weren't themselves attacking police officers? And it's helpful, again, to look at the history. When Congress passed Section 3 of the 14th Amendment, they weren't primarily interested in the lowly Confederate private who had been conscripted into the Army. They were interested in the leadership class. So, for example, Jefferson Davis, who was the president of the Confederacy, never fired a gun as part of the Civil War, but they definitely wanted it to apply to those leaders. And so the term engage has to include people who had a more indirect role. And the way that courts interpreted it in the years after the Civil War was that anyone who voluntarily does something to help or facilitate the insurrection, to help bring it to a successful conclusion on its own terms, other than a charitable contribution, counts as having engaged in insurrection. And there's case law on this from the 1860s and 1870s, where someone who, for example, served as a county sheriff under the Confederate government, that was deemed to have qualified as engaging in insurrection. Many of the people who were found to be disqualified were never convicted of a crime. In fact, most of the Confederate leaders were never convicted of a crime. So there's no requirement that somebody have been criminally convicted or even charged, but rather it just needs to be found that they voluntarily aided the insurrection. So that is the framework that we're pursuing in these two cases. In both of them, it begins, because of the structure of these particular states' laws, begins with a challenge before an administrative body, which then conducts a hearing, an evidentiary hearing where evidence is presented, and then there's a ruling which can then be appealed by either side into the court system. It works slightly differently in North Carolina and in Georgia. to give an update on the status of the cases. In both of these cases, the members of Congress have filed a federal lawsuit seeking to block the state process from going forward. So they don't want to be subject to their own state's candidacy challenge procedures. And they've alleged everything from the state candidacy challenge law is itself unconstitutional to an 1872 amnesty for ex-Confederates actually applies to them as well. In Georgia, we are scheduled for a hearing in the federal lawsuit on Friday, and the actual trial where we hope to cross-examine Marjorie Taylor Greene this coming Wednesday. In North Carolina, Cawthorn did manage to persuade a judge, a very recent appointee by former President Donald Trump, that he is covered by that 1872 amnesty for ex-Confederates, but we filed an emergency appeal to the Fourth Circuit to challenge that. I want to close by saying that in addition to the legal strategy, we are also partnering with another organization called Our Revolution on a grassroots approach where, outside of court cases and formal challenges, ordinary people around the country in all 50 states and DC can bring to the attention of the Secretary of State or whoever the chief elections official is in their state that this section of the Constitution applies, that it applies to people who are running for state office and federal office in 2022, and that if Donald Trump chooses to run again in 2024, it will apply to him as well. Thank you.
Great. Thank you so much, Ron, for helping us understand how you all are approaching these lawsuits. Lewis, we are obviously here talking about free speech at this conference. So can you help us understand the connection to free speech, the First Amendment?
Sure, at least I hope I can. Thank you very much. Well, first I want to say how grateful I am to be part of a conference. It's called Safeguarding Democracy. It's hard to imagine an issue more essential to safeguarding democracy than defending and enforcing this Section 3 that Ron has done such a good job explaining. So I would say with regard to free speech, let's make it simple. The representatives like Cawthorn have no free speech right at all to use language and engage in conduct that is insurrectionary, that supports that at all. It's like defamation, libel, shouting fire, fighting words. We have already carved out things that are just categorically not protected speech and activity. And in fact, this carve out for insurrectionists is probably the most sacred. It's written in the US Constitution in Section 3. But where we do have First Amendment rights, which I hope to get to speak on even further, is we the people, those of us here, the rest of us, to use our full panoply of First Amendment rights to assemble, petition, protest. I would urge nonviolently, march, demonstrate, write letters, to be in support of the protection and enforcement and existence of a Section 3 that bans, because what's important to note is that Cawthorn and Marjorie Taylor Greene take the position that there is no Section 3 anymore. That somehow they don't even have to be held accountable to such a concept. And it's a fairly preposterous notion. But I think they have not just they because they're different than me, it's well established. I realize that there's been arguments that January 6th was just the exercise of political speech. It seems to be preposterous on its face.
Great, thank you. So to be sure that I'm clear, it is not that they don't have the freedom to speak freely on issues that are relevant and important to their work and to their constituents, but when it is insurrectionary, I think that was the word you used, language, that is when it becomes a problem.
I certainly agree with that, and I think that's pretty well understood. They can believe that there was a great steal. I think the idea that if you want to believe that the election was stolen, that's different. But when you have action as Ron pointed out, aiding and abetting the peaceful transfer of power, and basically aiding and abetting action to lynch the vice president. That should be categorically has crossed the line into what's not protected.
Great, thank you. And I know you shared a few ideas about what we the people can do in terms of actions that individual citizens can take. Ron also shared sort of the grassroots organizing they're doing with their partnership with Our Revolution. Is there anything else that you would like to share on that subject?
Well, I just think whether you live in North Carolina or Georgia, all of us have a compelling interest to be concerned about engaging in our action as we the people to protect this phenomenon of a Section 3. Maybe I'm repeating, but Cawthorn has at this point successfully argued to a Trump appointee in North Carolina, federal judge, that there is no Section 3 anymore. And it's a little technical, but and I won't go into that. But that's something that should move us all to be engaged. And if I could, I'd like to maybe speak to some suggestions, particularly for the community that I think makes up most of the 200 people on this one, higher education and educators. Would that be okay?
Yes, I would like that.
Well, I guess the most overarching point I'd like to make is this one, and I hope it's not controversial. The courts never have and don't act in a vacuum. They don't simply neutrally call balls and strikes, evaluate the facts and apply the law. There's politics. And in fact, our First Amendment for the first 100 years was virtually meaningless until you could be locked up for criticizing the government. Until roughly 1900, World War I, labor movements, a lot of different things, religious freedoms. People were in the streets fussing and exercising these rights that seem to be stated in there. And then magically, roughly 1930, the Supreme Court said, well, from time immemorial, we recognize that people have these rights. So the courts won't acknowledge that people activism and what is politely called civil engagement, civic engagement, it's a great term. It's maybe a little academic for an activist like me, but that's power to the people. That's the people being involved and teaching in the classrooms. And I enjoyed hearing the previous, one of the previous speakers try to remind us that we don't have some neutral thing in our Constitution. Why is it that civil rights lawyers or activists are called left-leaning? We have sanctioned out an ethical moral center that's supposed to be equality, justice, fairly, equal protection. And we can teach this to the class in the classes. We could have universities make a public statement that this Section 3 should be protected. So I encourage all of us to not intellectualize or take to the ivory tower, but be in the bubbling, boiling nitty gritty of this particular matter, because it's really a serious threat if insurrectionists can get off scot-free at this moment in our history. Thank you.
All right, thank you both so much for helping us understand the context for these lawsuits and ways in which folks who aren't in North Carolina or Georgia can take action and why folks should be concerned. We do have a question about why the 2020 riots, as the person has labeled the summer events of 2020, I assume the ones in response to the killing of George Floyd, why those don't fit within Section 3. Ron, are you able to answer that for us?
Yeah, so it's important to remember that there are several elements to Section 3. The first is we have to be talking about someone who swore an oath of office to support the Constitution. So Section 3 does not apply at all. For better or for worse, it does not apply at all to private individuals who engaged in insurrection. It only applies to someone who already took the oath of office. Secondly, the term insurrection has a meaning. Words had meanings in the 19th century and they have meanings today. And the term insurrection legally was always understood as not a protest and more than a riot, that it has to have an element of attempting to defy the authority of the United States with the intent of overthrowing the lawfully constituted regime. So court cases in the 19th century, court cases in the 20th century have held that the insurrection must be specifically intended to overthrow the constituted government and take possession of its powers. So there's obviously a difference between in 2020, there were a lot of events. So I think the question is being a little bit general, but for example, in some cities, there were things that did devolve into riots. But in those cases, they were not taking over the powers of the United States in the same way that this violent attack on the US Capitol, which actually successfully took over the seat of government and blocked the peaceful transfer of power. So that's why there wasn't an insurrection. Again, if somebody wanted to challenge a candidate that they thought had sworn the oath of office to support the Constitution, but then had engaged in an insurrection that nobody else noticed what was an insurrection, they're welcome to do that. But we're focusing on January 6th because it actually was an insurrection against the United States.
Great, thank you for that. And then I think we have another question that's more around the technical language as well. Why does it say, and what does it mean, electoral college member? By elector of president and vice president instead of just president or vice president, do the president and vice president have a pass from this prohibition?
I can take that, and it's a great question. It does say elector of president or vice president, but the next words are hold any office, civil or military, under the United States. And in fact, during the discussions over the text of Section 3, someone asked that question: why is the president and vice president not specifically identified? Because obviously Congress would have thought it absurd that, let's say, Jefferson Davis, the former Confederate president, couldn't run for Congress, couldn't serve as a local district attorney, and yet he could become president of the United States. And the way that the congressional supporter of Section 3 responded in that debate was by pointing out those words, holding any office, and that the president holds an office under the United States. It may not have been the most clear phrasing, but that's where the president is covered.
Great, thank you so much. All right, we also have a question. This seems almost blatantly obvious that this section will successfully block these members. At the same time, Trump has installed 3 Supreme Court justices, one of whom has a wife who herself engaged in insurrection. Do we really believe the Supreme Court will rule in favor of these blocks, or will the Supreme Court pull a sort of Shelby County and rule that the circumstances now are different?
I can take a first crack at that, which is, we filed these actions in state proceedings, and they will get heard, for example, in Georgia, first by a Georgia state administrative judge, and then it will go up through the Georgia court system. It is possible that at some point it could be before the US Supreme Court, but we're a long way between here and there. And in the meantime, we think it's vitally important to hold these officials to account. We are scheduled, as of now, to cross-examine Marjorie Taylor Greene about her involvement in January 6th, basically a week from today, in a courtroom in Atlanta. That's further than the January 6th committee has gotten, and we intend to shine a light on her involvement. We can't predict exactly how things will play out because of all the judges in between, but the facts and the law are such that if the judges along the way take their job seriously, they will find that these individuals did engage in insurrection and are disqualified from office.
And I'd like to underscore the point Ron made earlier, that their nonprofit legal entity recognizes that being in sync with grassroots organizations is essential to achieve justice. So if I could scroll back and underscore my overarching principle, we, the people, cannot defer and wait and watch to see, wow, will those 6 conservative members of the US Supreme Court? That's citizenship malpractice, I would call it. If we aren't out there, let me see if I can, because we have to be short here. During the civil rights era, Martin Luther King, etc. Think about it. You had Thurgood Marshall before he was a Supreme Court justice. He filed powerful legal briefs, but I don't believe that the successes that came during that period were limited or caused by that. You also had Dr. King, you had Fannie Lou Hamer, you had people all over the country engaging in what I like to call the street brief. There's nothing wrong with the street brief. When those things are combined together, litigation is deemed a First Amendment right. The street activity, marches, sit-ins, I've said earlier nonviolent, but I would even support nonviolent civil disobedience. When those two are done in tandem, I think that is essentially our only recourse for fundamental change that is nonviolent. And I don't mean to be offensive, but I beg and plead our academic communities to get your hands dirty with this. Don't think that by having somebody saying the people united will never be defeated, that that's somehow simplistic and that power to the people is essential. We talk about the exercise of First Amendment rights. I realize it's silly. It's like a muscle. If we don't exercise those, all of us, it atrophies. And this is a historical moment where we face things inconceivable. Who would have thought of 9/11 and the Twin Towers being flown into? Who would think that we now have had an insurrection with discussion of lynching Mike Pence? That's my overarching plea, that we don't separate and wait for Ron and his brilliance and his team. And they've got a hell of a good team of lawyers in North Carolina helping them. But alone, they are at the whim of those 6 conservatives. Thanks for letting me.
Thank you. Thank you for that, Lewis, and for your passion. I think that was in direct response, or it is a direct response to one of the questions where someone says, there's just, there's so much that needs to be done, and there's so much mis and disinformation, and we need to take action. So I think that was a great call to us to do something and come alongside some of these other actions.
Well, just a 10-second plug for Ron. If you want to know more, Free Speech for People has a website, Myths and Realities. You can dig in, take a half hour and read up on further on this. Then you will be armed with the knowledge and the reality to be the good organizer that we're pleading for you to be, and classroom teacher to teach critical, creative, courageous thinking to our students.
This is great. So we do have a question. I know we're nearing our time, but Ron, if you could answer, what is the biggest obstacle that's facing these efforts to apply the 14th Amendment's disqualification clause to Madison Cawthorn? You touched on it a little bit, but yeah, if you could just repeat.
I mean, in the Cawthorn case, the state administrative tribunal was ready to move forward with a hearing, and then he brought an action in federal court to block it. And as I said, he drew a judge who was probably as favorable for him as he could have gotten, and that judge granted an injunction to stop the state proceeding. And the basis for this injunction was that an Amnesty Act passed in 1872 that applied to ex-Confederates somehow absolves all future insurrections as well. So that's what we're appealing in North Carolina. Again, Marjorie Taylor Greene has brought a similar federal lawsuit to try and block her state proceeding from moving forward, but that hasn't played out yet. But I think that is the obstacle that we have faced so far in the Cawthorn case. And once we hope to get that overturned on appeal and then get back into North Carolina and to be able to try the case. And he should be able to present arguments in his defense. We're not trying to say that he shouldn't have his day in court, but his day in court should be in the very state courts that are supposed to hear a candidacy challenge process.
All right, I'm going to ask one final question, and then we will close off our conversation a little bit earlier and give folks their time back. Are you all looking at implementing this Section 3 in any other instances? Or is it just at this point, Cawthorn and Marjorie Greene?
Well, I can answer for us at Free Speech for People. I don't want to give names and numbers, but we are planning to bring additional challenges in 2022 to other officials who, federal or state, who engaged in insurrection. And as I said at the top, in 2024, if Donald Trump runs for office again, we will challenge his candidacy on the same basis.
Wonderful. Well, this has been so interesting. And again, this is such a compelling topic. And again, we thank you both for your hard work and your passion. And we will turn it back over to Michelle. Thank you.
Like I said before, I'm such a legal eagle. I thought this was incredibly fascinating. And I think that I don't even know if our participants realize that we're seeing kind of the law develop in real time. And so I am so grateful to Ron and to Lewis and to Leslie for shepherding us through what was not just an interesting conversation, but was really a political science and history lesson. So I'm looking forward to following your organization's work. And I just want to tell you how much I appreciate your being here. And we're going to be continuing on in the spirit of activism, and what Lewis talked about. Our third panel is actually going to be about activism on campus. But before that, I want to let you get to know some of the national fellows from the UC National Center for Free Speech and Civic Engagement. Many of you may know that we have a National Fellows Program, and this year's is an incredible group. I wish you could meet them in person, but here you'll get to get a sense of them and the work that they are passionate about. Each year, the center selects fellows from a broad range of disciplines and backgrounds, such as law, journalism, higher education, technology, and government. Fellows receive funding to further the national conversation related to expression and democratic participation on college campuses. Their projects have a direct impact on individuals and communities across campus and are focused on enhancing our understanding of how free speech is and can be practiced in American higher education, as well as how to foster civic engagement in university life. Our fourth class is a remarkable group of individuals whose research focuses on challenging issues such as the roles of campus whistleblowers and bias response teams, pornography and free speech, as well as censorship in humanities curricula and academic museums and galleries. We are excited to present their work to you early this summer, followed by a series of interactive Fellows in the Field digital workshops. In the meantime, let's hear from them about their projects and why these issues are so important to their scholarship.
This is a time like none other, certainly in my lifetime, when we have so much attention on campus speech.
In my project, I'm investigating the moral dilemmas that humanities faculty face when developing their courses and curricula. What thinkers and what work should we as teachers assign? What do we do about, the racist elements in Kant or the anti-Semitism in Chaucer? These are tough questions. And the goal of my project is to sort of spell out the moral issues that are often in play with these canonical thinkers and works. And my hope is that we as faculty can make more informed decisions about who we teach, what we teach, and how we go about teaching it.
I have been interviewing decision makers in academic art museums and galleries, and I'm asking them what makes their job challenging, especially if they want to have conversations that are difficult to have. What are the factors in their work that are complicated and complex and difficult that needs to be in place for artists, art students, faculty members, guest curators, and campus museum staff to feel like they can really do the work that they want to do.
My fellows project is looking at the history of campus controversies over pornography and sexual speech. And over the past handful of decades, there have been a number of situations in which professors and invited guest lecturers to campus have caused quite an uproar when their courses or their lectures deal with the topic of pornography or sex media broadly defined. So part of my project is really thinking through what are some productive responses that can ensure and protect free speech and at the same time respond robustly to critics when they're voicing their complaints.
My project explores how historically Black colleges and universities have supported or provided opportunities for voice and engagement through civic participation, more specifically electoral engagement during the general election of 2020. And I really am curious about how historically Black colleges, how they were navigating this online virtual space or this in-person space, given so much that was going on during the time, and how that may, and how their actions may relate to their past, but then also what types of lessons can we learn going toward the future about how we can nurture safe spaces for student voice and student articulations of political views on historically Black college and university campuses. And many of the students on my campus recognize opportunities to get involved and to encourage other students to get involved.
The UC system is a beacon of light for sort of notions around sort of building civic identity and democracy. How are we actually exploring those values? How are we teaching those values? What kind of conversations are we having about that? And are there ways in which we can improve upon those dialogues? And so I really have wanted to do a project that explores this question of sort of these classes that we have that are sort of building sort of students' civic identity and identity around sort of being social change agents, and really explore sort of the ways in which we talk about, understand, explore race, racism, and anti-Blackness. And so the project is looking throughout the UC and looking at a number of courses in their curriculums and in their pedagogies to understand from an instructor perspective, but also from a student perspective, what's being learned, how are we reframing narratives, and where are their gaps?
Prior to becoming a faculty member, I was a student affairs practitioner at several universities. And I actually had the opportunity to lead a bias response team on one campus. And I experienced firsthand the tensions that teams and institutions faced in doing this work of trying to create that inclusive and equitable campus environment while simultaneously respecting and protecting free speech rights. And I'm really studying how universities respond to bias on campus and how they simultaneously navigate both free speech protections and creating an inclusive campus environment.
There are government agencies of all kinds, including public universities, that gag people from speaking publicly. I am looking at it, I'm using the California higher ed system as sort of a proxy for the country, a little microcosm of the country, looking at first, what are the free speech rights of people who work in the public sector, who work in government? And then second, how do the policies that are in place at these institutions measure up to what the courts have told us that the First Amendment or state law protects? Are these policies giving people the benefit of all of the freedoms that the law says they should have, or are they leading people to believe that they're going to get in trouble if they speak particularly to the news media without getting somebody's permission?
So one of the things I actually really liked about the center was that so many of the fellows seemed to be straddling that difficult line between theory and practice, right? Between basic research and scholarship, and then doing things that actually really try to affect change, either on college campuses or beyond. And the project that I'm working on, it is a project about doing something. I have been, for the past few years, working with a collection of people across a set of different campuses, and we have been working to develop what we call the Intercollegiate Civil Disagreement Partnership. And we bring together fellows from each of our universities to learn how to facilitate conversations across political difference.
The fight for freedom of speech, the fight for freedom of expression have long been under attack, have long been debated, have long been the center of public discourse. But what has remained the same is that we've had a community of people fighting for the right for those civil liberties to exist. And I think that like a part of this center is, sort of creating a community of folks to sort of fight for those civil liberties, whether that be in their sort of scholarship or whether that be in sort of their practices in their community.
When I saw that there was a higher ed institution that was actually wrapping their arms around free speech and civic engagement front and center and saying, we believe that colleges should walk the walk and not just talk the talk, I really wanted to be part of that.
To learn more about the center and the work of our fellows, visit us at freespeechcenter.universityofcalifornia.edu. I'm back, and I'm going to be looking forward to facilitating our fellows in the field workshops this summer when their work is complete. It's really hard to believe we're already at the end of the day, but we've perhaps saved the best for last. Our final panel focuses on one of the key elements, as Lewis Pitts so eloquently shared with us, a key element of speech and civic participation in a democracy, and that's activism. And we are extremely lucky to be joined by the authors of a forthcoming book, The Channels of Student Activism, How the Left and Right Are Winning and Losing in Campus Politics Today. Amy Binder and Jeff Kidder are both sociology professors, Amy at the University of California at San Diego and Jeff at Northern Illinois University. I want to give a special shout out to Amy, who was an inaugural member of the Center's Academic Advisory Board and has been an ardent supporter of our work. The Conversations moderator, Emerson Sykes, also has ties to the center. He was a former center fellow whose project focused on activism and the First Amendment. He's an attorney at the ACLU Speech, Privacy, and Technology Project, and I'm going to turn the mic over to him for what I know will be a spirited discussion. Take it away, Emerson.
Hi, Michelle.
Hi.
Can you see me? You cannot.
I cannot, but
now you can.
Now I can see you. I see you. Okay, and I'm going to disappear now.
Thank you, Michelle. Thanks for the introduction. It's a pleasure to be with everyone today. I think we're going to start, before we get into this discussion, with a poll. I'm inexperienced with polls, but hopefully we can make this work. So here's the poll. I'm working with Carrie, I believe, on this. The question is, do you think that public universities should be permitted to ban speakers from campus because of their message? Yes, no, not sure. And I'm getting a little message that hosts and panelists are not allowed to vote. I'm gonna have to take that up with Michelle. But once again, please vote. Do you think public universities should be permitted to ban speakers from campus because of their message? So I think we'll come back to the answer to that in a little while. But without further ado, I want to get into the discussion with the authors of this forthcoming book, The Channels of Student Activism, Professor Amy Binder and Professor Jeff Kidder. So I want to start with you, Amy, and apologies for the background noise. My 4-year-old is homesick today. But I want to start with you, Amy. The book is called The Channels of Student Activism, How the Left and the Right Are Winning and Losing in Campus Politics Today. And as Michelle said, I'm a First Amendment litigator. Most of the folks we've heard from so far today have been attorneys of some sort. And we talk about rights and liberties and government overstep and these sorts of things. We don't talk a lot about channels of activism. So can you talk a little bit about your approach as a sociologist and what you mean by channels of student activism?
Yeah, thank you very much. I'm just making sure that I can be heard and seen.
Yes.
Okay, great. Thanks. Thanks for the introduction, Michelle, and thanks for the question, Emerson. I want to start by giving a little bit of background on our sociological bona fides and what we've been doing in this area, Jeff and I, before. So prior to this project, Jeff and I had separately spent years studying conservative students at various types of universities and colleges. And we were both initially drawn to studying right-leaning students because there wasn't really enough known about them. I published a book with my co-author, Kate Wood, called Becoming Right, in which Kate and I found evidence that the type of university students attend, private elite or large public, strongly shapes conservative students' political identities and styles. So we were really looking at how particular institutions serve as cultural and organizational shapers of students' identities. And meanwhile, Jeff did research showing how students' conservative identities were not just a matter of which policy planks they believed in, but were profoundly linked to their personal identities. And both of us then moved on to other projects, despite the fact that we were frequently asked, so how does this work for liberals on campus? And we'd mostly say, that's a really great question. Somebody ought to study that. However, fast forward a couple of years later, after the election of Donald Trump and the protests that were roiling campuses while he was in office, and we realized that there was more work to do in the area of student activism, and that historically, scholars haven't really adequately tried to understand the interplay between progressive activism and conservatism, and that as sociologists, we could bring a kind of sociological perspective and view to how this is happening. So we joined forces to study how politically engaged students across the political spectrum were making sense of this particular moment by interviewing nearly 80 students on 4 public university campuses. And what we found is that there are these 2 distinct forms of mobilization, one on the left and one on the right, what we call the 2 channels of student activism. And very, very importantly, we found that both channels are organizationally produced. And each one has particular advantages, and they also suffer from opposing disadvantages for students, for higher ed, and for politics at large, including ideas about speech. So progressives, by which we mean both liberals and leftists, they are drawn inside their universities. They receive significant organizational support on campus, and they generally think that their politics fit well with the cultural ethos of faculty, administrators, and their classmates. This happens through student affairs offices, multicultural centers, and academic departments. These campus units lend not only ideological support to many left-leaning causes, but also internal funding and hands-on training in progressive organizing. The progressive channel, in other words, embeds left-leaning students within university institutional arrangements, and we see this as being the progressive channel's organizational advantages. At the same time, though, students' calls for action often seem extreme to their peers, particularly if those calls are from the far left. And their interpersonal ties in the campus units that I just named often chafe against what they perceive to be administrative inertia. So left-leaning students' demands for sweeping change rarely come to fruition, which means that progressive student activists, particularly students of color and leftists, can become disillusioned with their universities, and this raises contentiousness on campus. And still beyond that, progressive activists receive surprisingly little support from national and regional outside organizations, particularly, as we'll see in a moment, compared to conservative students, which means that their pathways into post-graduation political work is murky at best. And so growing skepticism over time about campus's support and students' uncertain connections with the political world, we see as progressive students' disadvantages. Conservatives, on the other hand, function as an outside insurgency. Conservative students aren't in the political majority on their campuses, on most campuses, and many feel isolated and unsupported by faculty and their classmates, and we consider these to be their organizational disadvantages. However, conservative students are able to compensate for this lack of internal support by tapping into a powerful external ecosystem that grants a lot of resources to them. And this outside channel helps guide students into adopting a discourse that is critical and often outright hostile to universities, which has been a winning strategy when it's amplified by conservative media and politicians. And also, much contemporary activism on the right involves bringing in provocative speakers to campus, something that was mentioned in a previous session, or viral tweeting about professors, and then benefiting from the outrage from the left, which is then parlayed into conservative politicians and pundits' vilification of cancel culture, which is said to be endemic on campuses. And then perhaps most importantly, but poorly understood, is that the conservative channel also promises to help funnel its young participants into future political careers by linking them to right-leaning politicians, think tanks, and media outlets within its ecosystems. And all of these connections between conservative students and this outside infrastructure are the organizational advantages enjoyed by conservative students. I want to make one more point before turning it back to you and to Jeff. So, like, taking all of this into account, the argument, the sociological argument that we've developed is, among other things, a rejoinder of sorts to Greg Lukianoff and Jonathan Haidt's book, The Coddling of the American Mind. This may be a book that's familiar to many participants on this Zoom today. And while we admire aspects of their book, especially as regards viewpoint diversity on campus, we think that Lukianoff and Haidt make sweeping generalizations out of extreme examples to support a psychological claim about the emotional fragility and stunted intellectualism of today's left-leaning college students, and then the cascading effects on all students and on campuses in general. But from our perspective, we don't think it's sufficient to point fingers at the shortcomings of Generation Z's collective psyche. And instead, we look to the organizational structures that make certain types of student activism more or less acceptable in different contexts. And this involves thinking about the institutions and groups on and off campus. And in this way, we describe students as organizationally channeled and less so emotionally coddled. And we see this showing up in all variety of students' activism on campus. We have a whole book about it, but very particularly in the area of speech, which I think you'll be getting into next with Jeff.
That's really, really helpful, Amy, and thanks for the introduction. I think it is important, so important, to bring nuance when people characterize, and whether it's the book you mentioned or sort of generally the propensity to characterize a whole group of people with a set of norms or values. But you have actually gone in depth and looked at, with a sociological lens, at who these folks are and how they're moving in concert. And I'll come back to you to talk a little more about we had a good description of the channels, and I want to get into more of the sort of why and how and what do we make of it when I come back to you. But let me turn to you, Jeff, to talk a little bit. I mean, it's, as I keep saying, it's a sociological approach, but it is very much about politics, right? And you have a sort of, one of your chapters is about the politics of students of campus speech, and you have a companion journal article with that title. So when you talk about a lot of ink has been spilled about the politics of speech on campus and fretting over campus culture, cancel culture, all sorts of buzzwords have been used to describe what may or may not be a crisis of speech on campus. So tell me, from your perspective, what do you mean when you talk about the politics of speech on campus?
Yeah, that's a good place to start. And I guess maybe a good, like, even sort of global way of thinking about it first is to sort of say that there's sort of two basic positions that people kind of take towards free speech and the First Amendment. And so on, like, one side, we have what can be called sort of like First Amendment absolutism. We can sort of think about like Justice Oliver Wendell Holmes and this view that it's a view that's more or less in line with sort of current American jurisprudence. And it really gives speakers a wide range of latitude in terms of the types of expressions that would legally be allowed, that you could make on a college campus or really any sort of public space. And the view behind this is really that democracies really require autonomous citizens who are endowed with the right to openly debate controversial issues. And then really even further, really that knowledge claims and take it for granted assumptions have to be challenged through this sort of like marketplace of ideas. And this idea of this sort of open marketplace of ideas, it really, among the absolutists, it holds true, even if that means allowing rather noxious viewpoints into the public debate. But then on the other side, we have what some scholars like Richard Delgado have referred to as First Amendment legal realism. And so from this perspective, some types of expression are actually harmful to democracy. And this is because within a social system, right, that's stratified by racial, gender, and sexual inequalities, that some forms of speech threaten the dignity of select groups, and thus expansive speech rights, which often tend to be monopolized by powerful groups, actually circumscribe participation within the public sphere, right? So weakening democracy. So if those are sort of the two, at the risk of simplification, the sort of two sort of sides to the speech debate, then this gets even more complicated when we bring in ideas about like legal consciousness or research from political psychologists about motivated reasoning. And legal consciousness is really the idea that there's a lot of abstractions about law that jurists and philosophers debate, but this all gets transformed as it gets filtered down into sort of everyday understandings about what the First Amendment actually means and what free speech should really look like. And then motivated reasoning is just the understanding that in real life situations, very few people actually adhere to philosophical first principles. Instead, all these abstract ideals just get dragged into the muddy waters of self-serving political interests. And there's actually a really interesting piece of research that Dan Kahan, along with some other co-researchers, did, where he took the same, or they took the same piece of video footage of a protest, and they told some people that the protest was of people protesting an abortion clinic. And then they told other people this exact same video footage was people protesting the military's former don't ask, don't tell policy. And the people were asked, that were shown this video, were asked to think about this case as if they were jurors on a First Amendment trial. And if people were predisposed to supporting the cause, what they believed was the cause of the protesters, then they described this, oh, you know, this is people expressing their free speech rights. But if people were predisposed to disagreeing with the protesters' cause, they claim to have seen people being harassed and bystanders being threatened. In other words, they claim that this wasn't a free speech case at all. It was really about all sorts of violations of other people's civic rights, you know, to be able to walk down the sidewalk and whatnot. And so what that research really shows is that, you know, what we hold, the sort of beliefs we hold in our mind can actually shape what we believe we've seen with our eyeballs, you know. And so in short, there's really, you know, not only are there a lot of various interpretations among legal scholars about what the First Amendment means, but there's all sorts of ways in which the idea of free speech actually gets used in rather instrumental ways, right? So people really symbolically support free speech, often just to sort of advance their immediate political goals. And there's all sorts of ways people can find to believe that they have a right to disregard speech rights if it challenges those goals. So as that is kind of like a background, you know, we can actually look at what some of the students who we interviewed, right? So we were talking with politically engaged students from across the political spectrum, how they discussed free expression and issues of inclusion and diversity on their campuses. And maybe not too surprising that conservatives took an absolutist stance, right? That individual speech rights trump basically all else. And most notably, when compared with progressives, who I'll bring up in a second here, all types of conservatives, from populists to traditionalists to libertarians, really framed speech rights in this sort of absolutist way. And I think a quote from one of the people we interviewed does a good job of capturing how students on the right think about speech. And so this is from a respondent we call Chris, who was in the midst of planning a visit from Charles Murray, who's a somewhat controversial social scientist, to visit his campus. And Chris told us, you don't learn new things by staying within your own little bubble. You truly don't. I hope that students realize they would be shutting down the cornerstone of American freedom, which is free speech, not hate speech, but free speech, by deplatforming Murray. He's not saying anything hateful. It's just something that people disagree with. And then Chris sort of went on and said, you know, you can of course shout down the speakers, fine. You have free speech too, but what's going to happen is your institution is going to be your tuition is going to be raised to pay these exorbitant security fees because we're going to keep bringing these people and we're going to keep broadening your minds. And in this rather long quote from Chris, we see sort of 4 key components to how conservatives think about speech when they were talking with us. Is that first, he positions free expression as a non-negotiable right? It's the cornerstone of American freedom. He positions free expression as a way of introducing heterodox viewpoints to his campus. In other words, a way to bring conservative ideas onto what he felt was a rather progressive university otherwise. He denies that really hate speech is a major concern, right? That instead it's just things people disagree with. And that fourth, efforts from students to deplatform guest speakers is really just a justification to keep bringing more speakers like that, right? We're going to keep broadening your minds. So the progressives, on the other hand, that we interviewed, they also talked about supporting free speech, but they coupled claims to speech rights along with an emphasis on needing to promote diversity and inclusion on their campuses. And oftentimes there was a tension between, they saw a tension between promoting speech rights or accepting speech rights and the goals of having a diverse and inclusive campus. So while there are really clear differences in how all the progressives talked about speech rights when compared with conservatives, progressives themselves were splintered into 2 very different camps. So leftists, or those kind of on the far left, tended to be willing to go quite far in limiting speech rights to promote the diversity goals. In other words, these are sort of the students that are leading the deplatforming efforts that we hear about in the media. And then liberals, as in students that are still progressive, but not on the far left, right? The liberals really weren't that far away from conservatives in acknowledging the need to protect speech rights. They just talked about the desire to balance that with diversity and inclusion too. And I can give a couple examples. Among liberals, we see this effort to sort of find this balance. And so we talked to a student we call Dexter, who is a college Democrat. And he told us, it's good to protest speakers you don't agree with, be active in that, but these controversial individuals should have the right to speak. If somebody tried to deplatform that speaker, I would disagree with them, right? So basically saying, sure, voice your opinion, protest, but still let people speak. But then we can contrast this with those further to the left who were more willing to see types of speech prohibited on their campus. So Isaac, for instance, told us that some rhetoric is just inherently violent. It inspires violence against minorities, against queer people, his quote. And I should be clear that when Isaac was talking about this, he wasn't talking about explicitly inspiring violence. He was talking about speech that would be pretty normal on Fox News programming or at a Republican political rally. And underscoring that point, another student, Donovan, justified efforts to deplatform conservatives because, as he saw it, quote, their economic policies reinforce sort of negative racial stereotypes, right? So it's not even that the people are making racial stereotypes, it's just that they support certain economic policies that can be extended out to have those kind of implications. But of course, students like Isaac and Donovan, they're really a minority on their campus. And almost by definition, students on the far left are not representative. So it is important to keep in mind that when we're talking about the far left, we're talking about a very small, but rather highly vocal minority. And it is these students, though, that are organizing the events that we do hear so much about in the media. And so ultimately, when talking with progressives, really what we found was a lot of ambiguity. And so there are people like Dexter who were very adamant about supporting speech rights. There were people like Isaac and Donovan that seemed equally committed to wanting to limit speech rights, at least in certain instances. But most progressives really just seemed unsure, or almost at times sort of self-contradictory, over what types of speech is currently protected by the First Amendment, and even beyond that, what types of speech should be permissible within a democratic society. And so I'll give this example of Alexa, who's another far left student.
Well,
And
Jeff,
so
can I
of
jump in
course,
before
yes.
you give more examples?
Yes,
Because
please.
I think it's really compelling, and it's actually a question about the examples, because you were talking about sort of the easy binary, the easy boxes that we put people into, and most people do sort of fall into these sort of absolutist or not boxes. And I always find myself as a progressive First Amendment advocate often agreeing with one side on the problem and the other side on the solution. That is to say, I agree with the analysis of the deep problems in our society, but sort of disagree that more censorship is the answer. And I think it's interesting to think about how these first principles ring hollow, especially the work that I'm doing right now is a lot around this sort of anti-CRT craze, right? And here we have people who are supposedly free speech absolutists now trying to severely limit what kinds of ideas are presented in education. So this really sort of resonated for me, and it brought to mind the question of sort of how did you find all these folks? These are really compelling, specific examples that really bring out the nuance of how different people view these complicated issues. And you said you were able to get a wide variety from across the political spectrum. Can you talk a little bit about how you went about finding these students and ensuring that there was a broad range? So often, I know many folks on this call will have the same experience of, self-selection is real. And so getting a truly representative sample is really hard.
Yeah. So, to be clear, our sample, to the extent our sample is representative, it's representative of a minority of students who are politically engaged, right? So we don't have any concrete data on what the average college student thinks. We have data on what, again, this very small subset of students that really self-identify as politically active. And so we targeted initially people that were involved in political groups on their campus. So college Democrats, college Republicans, Young Americans for Freedom, Young Democratic Socialists of America, those types of groups. And then we did snowball out from there, asking them, well, can you recommend some other people from your campus that are also involved in politics? And and so one of the things, as I sort of mentioned at the start, that really jumped out at us as we were looking after we completed all our interviews was there's all sorts of ways in which conservatives, for instance, are divided. I mean, there are real sort of battles between the more sort of populist, Trump-oriented conservatives and the sort of traditionalist, what used to be mainstream Republicanism, and then the libertarians are their own thing. But one area where we see this real strong convergence is the issue of what they see as free speech in this absolutist position, whereas progressives were really divided on this issue. And again, we see this divide between liberals and then the far left, and that's really, I think, where the battle lines of this speech debate on campus really are between conservatives and the far left. Because again, liberals, while addressing, much like you said, understanding the problems that the far left is identifying and agreeing with those problems, being less willing to try to just absolutely sort of censor speech. And oh yeah, go on.
No, there's so much to say. There's so much to go into. I want to come back to sort of digging into some of the nuances. Amy, I want to come back to you about the nuances of these two channels. But I want to break here just for a second to go back to our poll. So can we pull up the poll results? Because I think it might be a good segue to the next. Okay. So do you think that public universities should be permitted to ban speakers from campus because of their message? We have a significant majority saying no, 19% saying yes, and 23%, slightly more, saying not sure. So I guess we could make all sorts of extrapolations about the sort of who is attending Speech Matters today. But I wonder if that sort of indicates, Jeff, that we're sort of heavily in the, I would propose we're heavily in the liberal side with a strong contingent of the leftists and a strong showing of that very confusion and split that you were just talking about in not sure being the second most popular choice. So I think that's actually really resonant and reflective of what you were just discussing. But let me turn back to Amy to talk a little bit more about these individual channels. Can you talk about, we've sort of described them, we've looked at them from different angles. Can you talk about how they developed, the sort of why and the what do we make of it? What are the implications of these different dynamics?
Yeah, we have a theory for that, as a matter of fact. So, you guys did a really great job of summing up many of our findings, and bringing that poll in was really awesome. So thank you for doing that. One of the things that Jeff didn't get to as thoroughly is how organizations operate to set the table for these kinds of responses to speech from students. And so I want to kind of return to where I was earlier in the session, to think again about the outside and the inside channels and how these shape student responses. And I'm going to start with the right. So the reason why we think supporting unfettered speech rights and even like this noxious speech that Jeff was talking about has become such a ubiquitous part of college level conservatism is that student-led groups are operating within this larger outside channel. I don't think anybody would dispute that. And within that channel, there's an incentive structure that is increasingly oriented toward confrontation. And such tactics have been around for a while. I've been studying conservatives for a couple of decades now, but the appetite for stoking outrage is expanding on the right, as are efforts to capitalize on the negative responses that such provocations precipitate from the left when they do these events on campus. So many national conservative organizations see the First Amendment, we think, as a valuable tool for disrupting liberal hegemony on college campuses. And we found one of our interviewees, who's not a student, but who's a faculty advisor for the Turning Point chapter on his campus, to be extremely revealing. Turning Point, as many people know, is headed by Charlie Kirk and is a very confrontational, sensationalistic organization. And this faculty advisor said the following about the students in his group, and these are quotes. "Press is always good, you always want that. If somebody's going to do something, the clubs want to get it on YouTube. So you pick speakers that are creating something that will be explosive. It's not even about issues anymore. There's a conflict and students are behaving in that field of conflict, and that helps to get press. You go to your donors and it's very easy to show them, we're on CNN, give us more money." And then this interviewee, again, reminding you that this is a faculty advisor to Turning Point, so he's highly aware of the instrumental aims of the students in his group, says that visibility is huge for national organizations. Students are trying to find money, so they're willing to be utilized by national organizations in that manner. Students are also looking down the road. These kids are looking at internships, they're looking at training. These are the students that are going to end up in politics. And they know that by doing these types of events, especially if there's some visibility, it's all the better for them. So in other words, we see this incentive structure to bring confrontational forms of speech to score points on campus. But equally important about the conservative channel is that we think that outside organizations have been incredibly ingenious, I guess, about providing a ready-made and consistent script for students to adopt and apply to their activities. A lawyer for the Goldwater Institute, which created model legislation to be used to penalize students who disrupt speaking events, for example, said the reason people on the right are ginned up about free speech is because their speakers are the ones that are being disinvited and shouted down. So yeah, they love free speech right now because it's helping them to keep their message alive. And I have another quote from the president from Young Americans for Liberty, who's basically saying one of the things that happened when I took over was that we kept getting our speakers shut down and our students were getting redirected to free speech zones. And so whether new to the issue or have been on the scene for a while, organizations on the right cultivate and disseminate a script about the squelching of unpopular speech on liberal campuses. And this script or this cultural text is easily picked up by conservative students working with these national organizations to support speech on their campuses. And unfortunately, we see that there are some weaknesses in the progressive channel. Jeff, and you already mentioned that progressive students approach speech with more ambiguity and skepticism, particularly on the further reaches of the left. And it's really important to see the organizational story here too. Unlike conservative organizations that we studied, which have been producing this script, we think that civil liberties groups historically identified with the left, whether they're partisan or not, have been slower to generate such resources for students and others on campus. So while organizations like your own, Emerson and PEN America have for decades been on the front lines fighting for civil liberties, until recently, they haven't really shown the same dedicated commitment as conservative organizations to outreach programs and messaging for undergraduates, which we think has left progressive students without the same kinds of tools for making sense of speech rights. And not only that, but we think that the progressive inside channel on campus has been pretty complacent about teaching students about the history and value of free speech, which is something that we heard about in the video about so many of the fellows' projects that they're going to kind of zero in on this issue. And even more confusing about being complacent about producing anything like a script, we think that universities often produce contradictory messages about speech. So college and universities send conflicting signals with speech codes and principles of community, encouraging respectful, civil speech on the one hand, and statements of academic freedom and open inquiry promoting unfettered free speech on the other. Neither of these are bad things, but it's all oftentimes like confusing to students. And finally, we also think that the on again and off again close-knit relationships that administrators forge with progressives on campus, and particularly with underrepresented students, may be perceived by those students as an implicit promise from school leaders to provide protections from so-called hateful speech. So when that assumed protection is seen as missing during a contentious event, it amplifies the feelings of harm experienced by the campus community. I'd have a little bit more to say about how we think things are changing, both on the inside of universities and from outside organizations, but I think I'll leave it at that. So you can pursue questions.
Well, that's super helpful. I mean, I think, we have less than 10 minutes left. So there have been a few great questions in the Q&A, and I want to get to some of those now. But, the first one I think, Amy, we can answer very quickly is, where is your book and other research available?
Oh, thanks for asking that. It's coming out in May 2022, so in a couple of weeks. Knock on wood that supply chain issues do not slow it down. It's available from the University of Chicago Press website and other sources. Thank you for buying it.
Sure. And then the other question, which I think segues to what you were just about to say, and you can either take this or pass it off to Jeff, either way, but there's a question about, is this new? And I think you were going to talk about sort of how you have seen things changing over the years that you've been looking at this issue, which, as you mentioned, I think has been several years at this point. One of the things that, all of us First Amendment advocates sort of contend with is this idea that things used to be so much better, or that things are getting so much worse, or I am constantly pushing back against the idea that, there was some mythical times when there was no conflict on campuses. But do you want to talk a little bit about sort of where we are and where you see the trajectory? Are these truly new issues? Are we, heading for disaster? Is there still any hope?
I'd like to say that there's hope, but we're not overly optimistic that it's coming anytime soon. No, these are not new issues, but we think that, in focusing so much on the organization, the organizational terrain, we do see that organizations that have a lot of money, like we're talking about Turning Point, PragerU, they've got $25 million to work with. This is a lot of money targeted very specifically at student activists. And so this is just, clearly a sign that higher education is a fulcrum of the culture wars again. And I think in a way that is kind of unprecedented. And so it's going to take a lot of work to get out of this. Jeff and I did see some really positive possibilities in our research. We saw more activity among civil dialogue groups on campus, transpartisan groups on campus. And, we don't want to lay all of the responsibility at the feet of college students to get us out of this mess, but we see that some of their activities in these areas could be really positive. I don't know if Jeff wants to add to that answer, or if you want to move on.
Jeff, if you have something to add, go ahead.
I mean, I would just say that certainly there's nothing new about speech controversies and nothing new about debates about where the lines or limits of free speech are. But I do think that who identifies as sort of on the side of quote unquote free speech and who identifies in terms of protecting other values, those things do shift. And it's been a few decades in the making, but certainly compared to the 1960s, we see some major differences in terms of who is saying that their views are being stifled. And again, this gets back to how this idea of free speech is really just sort of a convenient symbol that gets thrown around as people are actually pursuing other political goals.
That's a helpful addition. I think I'll recognize that there is some pushback in the Q&A against the poll as being overly simplistic. I will fully cop to the idea that a one-sentence poll with a 3 multiple choice is overly simplistic. So certainly take that on board. And we won't get to all of the questions, but there are 2 more quick ones in the last 3 minutes if we can do sort of a rapid fire round. One question I wanted to hear your reaction to was whether or not students sort of, especially those who are more inclined to favor limits on free speech, how nuanced you got in terms of different kinds of areas on space, different kinds of spaces on campus. As we talk about a lot, campuses are schools. They're where students live. They're where students work. They're where they hang out. It's their social space, their professional space, their academic space, their living space, all in one, in a way that folks who don't live on campuses, I don't have to eat dinner across from my political rivals. So I'm curious to the extent to which, especially the students who were skeptical of robust protections for free speech, had carve-outs for different types of spaces, the public square versus the classroom versus the dormitory.
Yeah, Amy might have something to add here too, but I would just say that we talked in very sort of general terms about, whether or not certain speakers should be allowed on campus. And I don't think that most students, that at least under the context in which we were talking with them, that type of distinction was that important. What really mattered was, are people who are felt to create unsafe environments for certain portions of our community, are their voices being allowed to be heard on campus? That seemed to be the main concern. But I would add that Amy's last book with Kate Wood talks about how being connected on your campus, the more campuses create connections between students, the less that provocative forms of politics are appealing. In other words, if you are going to be sitting next to somebody at the cafeteria table, you're going to be far less likely to want to have pissed them off in the hour before, right?
Well, and in some ways, in the quote, the sort of traditional forum analysis, an independent speaker in an evening session or something like that would be the place where you would have the most robust protection. So if folks are willing to restrict that, in some ways, we can infer that they'd be much more eager to restrict it in other settings. And maybe, Amy, coming back to your last point, you were talking about the differences in organizational investments in these different channels. And we had a good question about sort of following the money, and to what extent do you think this? We talked about emphasis and support. Does this really boil down to dollars in a minute, if you can?
Well, dollars make a lot of difference. One thing that we also found in the conservative channel is that that's not monolithic either. There are some more kind of civil organizations, but they're spending less money on getting more bipartisan conversations going and other things. So we see a lot of the money being funneled directly to this much more confrontational type of approach toward universities, making universities the center of the culture wars, and really, trying to invigorate students around that notion.
Great. Well, I there is hours and hours more to say and pages of your book to read. So we look forward to the release of the book. Again, the title is The Channels of Student Activism, How the Left and the Right Are Winning and Losing in Campus Politics Today. Thank you so much, Professor Binder, Professor Kidder. It's been a great pleasure. I'll turn it back over to Michelle.
And I want to thank Emerson for, of course, facilitating a terrific conversation, and both professors. I'm excited to read the book. I actually kind of just wanted to mention that I think it's really great that actually 2 of our 3 sessions today really were about books that are forthcoming, because as we're talking about things that are important to our liberal democracy and education, I guess for me as an avid reader who thinks that like some people want to be on their Peloton and I just want to be reading a book, I'm glad that is part of what this conference is about. And, we've had a very full day. I kind of can't believe that we're already at the end, but the good news for people that are sad that we're ending is that there is more, and there is more to come tomorrow. And we're going to be continuing to talk about safeguarding democracy. Tomorrow, we're going to be continuing what Amy and Jeff and Emerson started, which was diving into the university. We're going to hear from 2 university presidents, 2 leading thinkers in the area of civic youth participation. And most importantly, we're going to hear from students themselves about what drives them to work to better our system of government. If you enjoyed today's programming and you'd like to support the center, you can make a donation through our website, freespeechcenter.universityofcalifornia.edu. We make all of our research and programming accessible at no cost, and we'd appreciate your support. If you or your organization wants to be a sponsor for our 2023 Speech Matters Conference or other programming, please reach out to me. Otherwise, tune in tomorrow, same time, same place, same link. 10 a.m. Pacific Daylight and 1 p.m. Eastern Daylight. Check out our podcast, Speech Matters, and we'll see you tomorrow.